New Jersey lawmakers are introducing some of the harshest gun carry laws in the country.
State lawmakers claim they were forced to pass this new law after the Supreme Court struck down restrictive gun licensing laws.
You're going to trap people into committing third-degree and fourth-degree crimes by allowing this patchwork of regulation to exist.
Gun rights advocates in New Jersey are headed back to federal court to once again fight a state law that bans concealed carry of guns.
Do we have a massive victory for our Second Amendment rights, or will we be let down yet again with a major disappointment?
A federal judge just cited a law that never existed, one that actually referenced a king, in a country that fought a revolution to get rid of kings. And that's not even the wildest part of what just happened in Philadelphia. The United States Court of Appeals for the Third Circuit just held a massive hearing, every single active judge on the bench, to decide whether New Jersey's sweeping gun restrictions survive constitutional scrutiny. And based on what unfolded during oral arguments, the state of New Jersey may be in serious trouble. Let me set the stage for you so you understand why this matters far beyond New Jersey's borders. After the Supreme Court's landmark 2022 decision in Bruen, which confirmed that Americans have a fundamental right to carry firearms in public for self-defense, several states essentially threw a tantrum. They couldn't ban carrying outright anymore, so they got creative. And by creative, I mean they tried to make the right to carry meaningless by declaring practically every square inch of public space a so-called sensitive place where guns are prohibited. New Jersey was one of the worst offenders. We're talking about a state that designated something like 24 or 25 broad categories of locations as government-mandated gun-free zones: beaches, colleges, schools, childcare facilities, hospitals, nursery schools, youth sporting events, museums, libraries, zoos, theaters, casinos, stadiums, healthcare facilities, the list goes on and on and on. They also adopted what's been called the vampire rule, which says that even if you have a valid concealed carry license, you cannot bring your firearm onto any private property open to the public, gas stations, grocery stores, laundromats, anywhere, unless you get specific affirmative consent from the property owner. Essentially, your right to carry exists on paper but nowhere in practice. Now, lawsuits were filed almost immediately. A federal district judge, Judge Bum, issued a strong ruling in favor of the Second Amendment, finding that New Jersey couldn't demonstrate any historical tradition supporting these sweeping bans. She enjoined many of these laws. But then the case went up to the Third Circuit, and the three-judge panel that was randomly drawn was not favorable. One excellent judge, Judge David Porter, sat on that panel, but he was outnumbered 2-1. After an agonizing wait of roughly 2 years, that panel finally issued its opinion in September 2025, ruling that virtually all of New Jersey's restrictions were constitutional. Judge Porter wrote a powerful dissent arguing that the state had failed to identify sufficient historical analog laws from the founding era and had failed to articulate any coherent principle that would justify banning firearms in places like beaches, zoos, museums, and libraries. Here's where the story takes a dramatic turn. Between that panel decision and what just happened this week, 2 new judges were confirmed to the Third Circuit, Judge Jennifer Mascott and Judge Emil Bowe. Both were confirmed quickly by the Senate, and President Trump, to his credit, ensured their commissions were signed and delivered so they could be sworn in and participate in this case. Their arrival shifted the composition of the court. A petition was filed asking the full court to rehear the case en banc, meaning all active judges would sit together rather than just a 3-judge panel, and the court granted that petition. So this week, every active judge on the Third Circuit heard oral arguments in the consolidated cases challenging New Jersey's sensitive places regime. And from everything that transpired during those arguments, the state of New Jersey appeared to be drowning. Now let me tell you about the moment that perfectly encapsulates how desperate the anti-gun side has become, because this is genuinely remarkable. One of the judges, Judge Cindy Chung, who was on the original panel that ruled against the Second Amendment back in September, pressed the attorneys representing gun owners about a supposedly critical historical statute. She brought up what she described as a 1792 North Carolina law that she believed was directly on point and strongly supported New Jersey's position. She presented it as though it was a knockout blow. There was just one small problem. That statute never existed. It was never enacted. It was never real. The reference to this supposed law traces back to a compendium compiled by a young lawyer who had literally just graduated from law school and been admitted to the bar months earlier. He included it in his collection of laws, but the statute itself was never actually passed by North Carolina's legislature. And here's the detail that makes this almost comedic. The text of this phantom statute, this law that supposedly existed in the United States in 1792, contained a reference to the king and the king's appointees. Now think about that for just a moment. By 1792, the American Revolution had been won years earlier. The Constitution had been ratified, the Bill of Rights had been adopted, King George III had been sent packing, and yet a federal judge was citing, with apparent confidence, a supposed American law from that era that referenced a king. That should have been a rather obvious red flag that something was off. It was an embarrassing moment, and it revealed just how thin the historical evidence supporting these gun bans really is. But the problems for New Jersey go far deeper than one judge citing a non-existent statute. Let's walk through the legal framework to understand why the state's position is fundamentally weak. Under the Bruen methodology, you start with the plain text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed. The right to keep means the right to possess. The right to bear means the right to carry. When a law restricts your ability to carry a handgun into dozens of categories of public places, even when you hold a valid concealed carry permit and you're carrying peaceably, that law plainly implicates the Second Amendment's text. That's not controversial. That's just reading the words. Once the plain text is implicated, the burden shifts entirely to the government, in this case, New Jersey, to demonstrate that its restrictions are consistent with the nation's historical tradition of firearm regulation. And this is where New Jersey's case collapses. The state has to identify a sufficient number of historical analog laws from the relevant time period, which should be 1791, when the Second Amendment was adopted, and then derive a coherent principle from those laws that would justify banning firearms in all these modern locations. What did New Jersey come up with? Essentially nothing of substance. And we know historically that Americans were allowed to carry firearms virtually everywhere, as long as they did so peaceably. We know this not just from the absence of prohibitory laws, but from affirmative historical evidence. During the Boston Massacre trial of 1770, John Adams himself, one of our most important founders, argued that the citizens of Boston were entitled to carry arms in that dense urban area for defensive purposes. The distinction was never about where you carried. It was about how and why. Carrying peaceably for self-defense was perfectly lawful. What was prohibited was carrying arms to the terror of the people, meaning using your weapon to intimidate, threaten, or frighten others. Brandishing, menacing, terrorizing, that was illegal then and it's illegal now. Nobody disputes that. What New Jersey and its allies are attempting to do is take those historical laws against terrorizing the public and stretch them beyond recognition to cover the peaceful, concealed carry of firearms by law-abiding citizens. But the Supreme Court already rejected that exact argument in Bruen. They specifically addressed the Statute of Northampton and similar laws and said no, those provisions targeted the misuse of arms, not their peaceful possession. The court also rejected the idea that you can declare an entire area like Manhattan a sensitive place simply because people congregate there. If congregation alone justified a gun ban, then every city, every town, every public gathering would become a gun-free zone, and the right to bear arms would be effectively erased. So what places can the government legitimately designate as sensitive? The Supreme Court in Bruen identified a very narrow set of examples grounded in historical practice: courthouses, polling places, and legislative chambers. That's the universe of historically supported sensitive places. And when you examine what those places all had in common at the founding, a clear and coherent principle emerges. Every single one of those locations featured what can best be described as comprehensive security. They had limited points of entry and exit that were guarded or controlled. They had mechanisms to ensure that no one with hostile intent could bring a weapon inside. And they were protected by armed personnel: bailiffs in courthouses, sheriffs and their deputies at polling places, sergeants at arms in legislative chambers. All 13 original states had these arrangements. It was a universal understanding. The principle is straightforward and historically grounded. The government can temporarily disarm you in a specific location, but only if it takes responsibility for your safety while you're there. That means controlled access points, screening to prevent weapons from entering, and armed security to protect everyone inside. Think about how this works in modern practice. When you enter the secure area of an airport through TSA screening, you're in a sterile environment with armed federal officers. When you enter a federal courthouse, you pass through metal detectors and armed marshals are present throughout the building. When you enter Congress, the same protocols apply. That's comprehensive security. It's objective, it's measurable. And federal judges can easily apply this standard because they literally experience it every single day of their professional lives. They walk through metal detectors, past armed marshals, into secured courthouses. They know exactly what comprehensive security looks like because they live it. Now contrast that with New Jersey's approach. New Jersey wants to ban guns at beaches. Are there metal detectors at the beach? Armed guards patrolling the shoreline? Controlled entry points? Of course not. Libraries, zoos, museums, youth sporting events? None of these places have anything remotely resembling comprehensive security. The government is simply slapping a no guns sign on a location and calling it a sensitive place without taking any actual responsibility for the safety of the people it's disarming. That's not how it worked historically, and it shouldn't be how it works now. When the government refuses to provide comprehensive security, two things become clear. First, you cannot be stripped of your right to self-defense in that location, because if a threat materializes, no one is there to protect you. And second, the government's own inaction reveals that it doesn't truly believe the location is so sensitive that firearms pose an unacceptable risk. If they really believe that, they'd do something about it beyond posting a sign. Actions speak louder than words, and when the government's actions don't match its rhetoric, the designation cannot stand. This principle has been gaining traction in legal scholarship, and based on how the oral arguments went this week, it appears to be gaining traction with the judges of the Third Circuit as well. The questions directed at New Jersey's attorneys were pointed and skeptical. The state struggled to articulate any historically grounded principle that would support its expansive list of sensitive places, and the arrival of the new judges has clearly shifted the dynamics of this court. Now, nothing is guaranteed, the opinion hasn't been written yet, and the future remains unwritten. But based on the tenor of the arguments, the weakness of New Jersey's historical evidence, and the composition of the en-banc court, there is strong reason to be optimistic that many of these restrictions are going to be struck down. A decision could come sometime over the summer, possibly sooner. The implications extend far beyond New Jersey. Whatever the Third Circuit decides will send a powerful signal to courts across the country about what the sensitive places doctrine actually means and how far states can push it. If the court adopts a rigorous, historically grounded standard, particularly one centered on comprehensive security, it will be extremely difficult for any state to maintain the kind of sweeping gun-free zones that places like New Jersey, California, New York, and Hawaii have attempted to impose. The Second Amendment means what it says. The right of the people to keep and bear arms shall not be infringed. And when a state tries to make that right meaningless by banning firearms from every conceivable public location without providing any security in return, that's not regulation, that's nullification, and the courts are starting to recognize the difference. That's it for today, folks. See you in the next video.